predicated on your idea, in fact, being a secret. If you've already told lots of people about it and how you do it, it's no longer a secret, and the patent office will not give you a patent. My name is Barry Fogarty. I'm a serial entrepreneur, as was mentioned earlier. I'm not a lawyer. I don't know a whole lot about law, but I know a little bit about starting companies and where intellectual property has some relevance. So what I thought I'd do today is give you my perspective. In terms of my background, Lisa has told you a little bit about it. The only other thing that I'll add, so you have some context, is my first company was a production services company. We had some expertise in the area of creating photographically textured three-dimensional models. We did a lot of work for the automotive industry. We would build these interactive pieces for the web and broadcast. This is the early 2000s. That would allow you to interact with a vehicle. The doors would open. You could go inside. You could visualize what it would be like to drive and do things like that. Along the way, we had an idea for a software product, and that became Octopus. And I'm going to go into some detail on the Octopus experience, and then most importantly, tell you the top 5 things that I learned along the way. Okay, so I'll try and be brief so that there's some time for questions afterwards. So, like everything in life, there is a beginning and a middle and an end. And in the beginning, for Octopus, we had an aha moment. My co-founder was attempting to solve a problem that we encountered on a, not daily basis, but certainly on a monthly basis. We were retained by advertising agencies, generally based in New York or Los Angeles. We would create these three-dimensional models. We would need the creative director in the agency to sign off on the model on a timely basis. We had the vehicle under the lights in the studio. We needed a sign-off before we could release the vehicle. The creative directors would never get back to us on the time frame that we wanted. We would email, we would FTP. We had all kinds of review mechanisms in place, and none of them worked. So we went looking for a synchronous 3D viewer that would allow us to, in real time with this creative director, look at that model, manipulate it in real time so we could turn it over and they would see what we were doing, or they could take control and they could draw a circle on a problematic area. And we couldn't find anything that worked, anything that met our criteria. We had some particular criteria about ease of use and cost and things like that. So my co-founder in that company, over a weekend, coded out something. And it worked really, really, really well. And we started to use it with our clients, and we found ourselves getting into a situation where some of our clients were more interested in our software than they had been in our production services. So we kind of did a bit of a pivot as a company. Within a month of that aha moment, we had filed our first patent application. Within another 2 or 3 weeks, we had an IP law firm on board to help us protect ourselves. We won a major client very early. We moved into Mars. We were actually one of the first startups in Mars. And we, within, I guess, about a year, we had venture capital backing us up. So things were going really quite well. In the middle, we launched a publicly available version of our software in San Francisco at the Web 2.0 conference. That was a really big deal for us. We had a very successful launch. We were selected as one of the top 5 new technologies demoed at this conference. We then became one of the top 100 web apps in the world for 3 years in a row. So that was really good, very, very exciting. And the great thing about winning awards was that it opened a lot of doors for us. So we were able to establish really important and quite valuable relationships with some of the biggest companies in the world. That's the middle. And then the end came for us. And one of the things that I discovered was that while awards are really, really useful, you can't put them in the bank account. They really don't have any financial value. They can create opportunities for you, but, and I'll try and be brief about this, we discovered that while we had a great idea and we had some great intellectual property, my colleagues and I were spectacularly bad at turning that into a business. we didn't generate sufficient revenue or users to give our venture capital backers, who were very, very good. The reason we had some issues in the marketplace had nothing to do with our VC partners. It was really my colleagues and I and our plan. And so this is like 2008, 2009. The economy, the VC economy anyway, is starting to tank. Our VCs come to us and say, you're running out of runway. We can't continue to put money in you. We don't see a path to profitability. And so we're going to have to make some big changes. And so together with our VC partners, we downsized dramatically. We went from about 15 or 20 people down to 2 or 3 people. And just a quick little side point about this. One of the reasons why I think we were unsuccessful in the marketplace, or we had some success, but we weren't sufficiently successful, let's put it, was that I imagine that all of you know about the lean methodology, the lean approach to building software. That's a really good idea. We didn't do that. And one of the mistakes that we made was we never really had product market fit. We had some features that some markets were interested in, and yet we didn't have a complete set of features for them. So we ended up kind of bumping around and having some clients in this sector and some clients in that sector. The other big problem that we had, and this goes back to the lean methodology, is we didn't pivot. So when there was an indication that, okay, well, if we shift a little bit and go after this audience, we can have success. We didn't do that. We kind of got, I think a little bit, in retrospect, caught up on executing a plan that we had identified 12 or 18 months earlier, and let's ignore all the evidence to the contrary. So we started to downsize. And then I called my lawyer at the IP law firm that we worked with, and I said, look, I have some really, really bad news. And he said, well, I've got some really, really good news. And I said, okay, well, let me get mine off my chest first. And I said, so things are going really quite badly. The VCs are turning off the taps. I think we're kind of screwed. And he said, well, I think you might want to have another conversation with the VCs, because I just had a conversation an hour earlier with the US Patent Office. And we had made our applications a few years earlier. They were winding their way through the US PTO. And they always come up with reasons why they don't think it's inventive and unique and things like that. And then your lawyers come back and say, well, we think it is. And they come to us for some further information. But anyway, he said, I just spoke to the patent officer, and they've withdrawn all their remaining objections, and it looks like your first patents are going to grant within the next 2 weeks. So we did go to the VCs and say, look, we have some offers on the company right now, some people who were interested in buying it, but they weren't particularly generous or sufficient. And we decided that, well, you know what, let's double down on our patent portfolio. We have a good idea. The market is moving in a direction that our patents will be increasingly relevant to. And so let's concentrate on that. And then at the same time, and this is all happening quite strangely, all within a 2 or 3 week period. But within that period, we started to see some products be released in the marketplace by some very, very large, well-known firms that we believed very strongly infringed on our intellectual property. So we continued to make some investments in intellectual property. We worked closely with our firm. We filed additional patent applications and continuations and things like that. And then after about a year, we felt we were ready. At this point, we had 5 patents fully granted. And we started to work with a gentleman here in Toronto by the name of Loudon Owen. Does anybody know Loudon by any chance? So Loudon is either famous or infamous, depending on what side of the fence you sit on. Loudon is a Toronto-based guy. He's a VC and a lawyer, which personally I think is unfair. I think you can be a VC or a lawyer, but you really shouldn't be both of those things. Loudon was a backer of a company called I4I. I4I, Toronto-based, had 1 patent. And they believed very strongly that Microsoft was infringing on that patent. And they challenged Microsoft, which is, that's a formidable opponent. And they sued Microsoft, and they won. And Microsoft, being Microsoft, appealed it. And Microsoft lost the appeal. And it went through various levels of patent review all the way to the US Supreme Court. And the US Supreme Court upheld the decision against Microsoft. And Microsoft had to write a check for $240 million to Loudon and his firm, and his investors, of course. Didn't go to him personally. So when we were ready, through my lawyers, I got introduced to Loudon and Mike Kanata, his partner at PMI. And so we retained them to help us figure out what we might be able to do with our patent portfolio. And so within about 6 months, maybe 12 months of that period, we sold our patent portfolio. I can't tell you who bought it, and I can't tell you how much they paid. I can tell you that nobody paid $240 million for it. But we did have an exit, and we had a reasonable exit. So here are the 5 things that I learned about intellectual property along the way, and I'll try and be brief about it. I think you have to be extraordinarily careful about public disclosure. At its core, and from a layman's perspective, what the Patent Office is doing is saying, tell me your secret. And if it meets the test for patentability, then we'll publish it, and it becomes available to everybody, which will advance society and the public good. But in exchange for telling us your secret, we will give you some rights to it. You own that, and people who want to use your idea will have to strike some kind of a deal with you. That's predicated on your idea, in fact, being a secret. If you've already told lots of people about it and how you do it, it's no longer a secret, and the Patent Office will not give you a patent. This is fairly embarrassing, but what the heck. In our case, when we had the aha moment, one of the companies that we weren't working with them at the point, we were talking about working with them, was IBM. We had done some work in the museum sectors, digitizing small items and larger items. IBM was behind a project in Egypt where they were looking to have people digitize artifacts. And so we were one of the companies that they were talking to. And so one of their senior people came into our studio to take a look at our technology for capturing items. And at the end of it, because just literally 4 or 5 days earlier, my co-founder had this idea and had coded out something. And so we said to this woman from IBM, we said, hey, we've been playing with this idea, and do you want to see it? And she said, sure. And so we showed her the first live demo of our technology. And my co-founder was in another room. I'm in one room. We're synchronously looking at this 3-dimensional object, and I yell out to him, and I said, okay, turn it around. And he turns it around and flips it over, and it's all in absolute real time. Again, without going too deeply into it, our uniqueness was that we figured out a way that we can minimize latency and lag, so that as he manipulated it, no matter where in the world I was seeing it in real time as well. So she was, I thought, suitably impressed. And then I said, do you want to know how we make that happen? And she said, no, I don't think you want to tell me that. And I said, well, no, I really do want to tell you that. I'm really proud of it. And she said, no. You really don't want to tell me this. And what you need to do is not tell anybody. And you need to get a lawyer really, really quickly to find out if you have intellectual property. Because if you do, don't be telling anyone. So you need to figure out if you have intellectual property. And this is easier said than done. I absolutely get this. And I'm sure that all of you, if you're starting things, you really don't know if you have intellectual property. And how could you? You're not a lawyer. So as these gentlemen were saying, there's a test for patentability. The USPTO needs to know whether or not your idea is unique and non-obvious and useful. So you can read up and you can try and figure that out. You need to figure out what other patents exist in that same area. And are you different or fundamentally opposed to any of them? You need to understand if there are similar products and services in the marketplace, well, how do they accomplish that end thing that you've accomplished? And that's not easily done. It sometimes requires a little bit of reverse engineering. So again, I don't mean to be flip about it, but that's a hard thing to do. And if you can figure out whether or not you have intellectual property, good on you. And if you do have intellectual property, then you have to figure out what you're going to do with it. And what you can't do is just say, well, I'm going to file an application for patent, and then I'm good. Everything's going to be fine. Because that's probably not the least of it, but it's one of the smallest items. So what I feel very strongly you need to do once you determine if you have intellectual property, and actually, to be really honest with you, I think you need to do this when you begin to think that you might have some intellectual property, and that is find a really good intellectual property law firm that'll give you a little bit of time. So by working with them, we were able to kind of really go in and say, okay, well, you know what, we do in fact have some intellectual property. So what are we going to do about it? What are we going to file? Because as these gentlemen were saying, if you file something, then it becomes public knowledge. You may well choose, as we did, to not disclose some things, to keep those as trade secrets, so we never ever did disclose those things. The other thing that's really important is you need to ensure that you have freedom to operate. So what that means is you need to know that you're not infringing on someone else's intellectual property, because what you really don't want to see happen is the day that you launch your product, someone sends you a cease and desist letter saying, hey, you're infringing on my intellectual property, because then you're potentially really quite screwed there. The other thing that you need to do is, if you have a business and that business is going to evolve, and if your product, your solution, your service is going to evolve, you need to make sure that your patent filings stay with you. So, you know, if I have a patent filing for that iteration of my product, but that iteration of my product is not in the marketplace anymore, that patent may or may not be particularly valuable. So you want to be anticipatory and know where you're going and make sure that your patent filings are live and organic. You need to maintain thorough records, and again, I'll embarrass myself a little bit here. You have to archive everything. If you think you may end up in litigation, and no one ever thinks they're going to end up in litigation in the beginning, but for us, towards the end of our process, we really did believe that we were going to sue someone, or that they might sue us. And so we knew that we really needed to be able to go back and prove that in meetings with those companies or other companies, we said this, they said that, and so on and so forth. The last point's the embarrassing thing. Our lawyers had told us to make sure that we have IP, intellectual property assignments, from all of our employees and all of our consultants. And we didn't really pay sufficient attention to that advice. And it's really a lot easier to get a consultant to sign an IP assignment when you're bringing them on. It's a lot harder. Oh my God, it's so much harder to get them to sign that agreement after you terminated them. And 2 years later, when they know that you may be moving towards litigation and they know that you really, really need that signature on a piece of paper. So I would urge you to, again, when you get counsel, they'll help you draft these things. And it can be a really short document, but make sure that you have people assigning any intellectual property rights to you. Last point I wanted to make is that if you get to the point of a patent transaction, then you really need to ensure that in addition to your patent counsel and your corporate counsel, you have other people giving you guidance. Patent transactions are complicated, like many things in life. One of the reasons they're complicated is that there is significant reward available. A lot of companies, as from some of the slides we've seen, a lot of companies recognize that they need intellectual property to back up their inventions. And so they are often looking to acquire intellectual property rights. I know that when we were starting to look to sell our portfolio, we had offers from our competitors, we had offers from our clients, and others as well. But there are some huge dangers when it comes to a patent transaction, and I'll just mention, because I have 10 seconds left, validity challenges. So if company A thinks that I'm going to challenge them, I think that they're infringing, what they will by default automatically do is they will go to the patent office and say, you know what, I think you granted this company a patent erroneously, and I want you to re-examine that. And if they are a big and smart and powerful company and you are a small company, you're really in a difficult battle. I'm not suggesting that the US PTO is biased towards larger companies at all. But if you don't have the resources to engage in a legal battle, you will quite possibly lose that legal battle.